First off, for most prosecutors, the high 90% are honest people of integrity, and the furthest thing from their mind is convicting an innocent person. But the fact of the matter is that prosecutors see almost everyone they deal with as a law violator. And I call it the Al Capone mentality. They look at someone, they find that they've done something wrong, they've violated some law, and now it's a matter of bringing all the forces that they have at their disposal, the FBI, the IRS, the various investigative agencies, and making a case that they can win. And unfortunately, sometimes, when a prosecutor feels they could lose the case, and there often comes that point, they then begin to think, if I lose this case, it will be very bad for me professionally. I won't get a promotion within the Department of Justice or the District Attorney's Office. I won't get that very lush job in private practice. I won't get a judgeship because I'll be known as the lawyer, the prosecutor, who lost a case that may be very visible. When prosecutors get into the heat of battle, something takes over. The competitive spirit, their reputational implications, and they want to win at all costs. And when that takes over, they then cheat to win. And it's so easy to do because they're rarely caught.
And if they are caught, what happens?
Little or nothing. And it's rare, if ever, that anyone is punished. And that, of course, is the problem. If they aren't punished, if there are not ramifications for this kind of intentional misconduct, I'm not saying mistake. Everybody makes mistakes. You may not know something's in your file, but if you have a handwritten note that says something contrary to what your chief witness is going to say at trial, that's a red flare in the middle of a dark ocean. You know that has to be turned over based on the Constitution, based on the Brady case.
The Supreme Court has ruled in these violations, in a case involving someone who spent 10 years on death row, you can't sue the prosecutors.
That's correct. One of the strongest principles in law, and one of the more difficult ones for me to understand, is the virtual absolute immunity that prosecutors have. They can intentionally engage in wrongdoing, obtain a conviction, put a person in jail for decades, and when caught, there's no lawsuit that can be brought by that individual person who's just lost a decade or two of their lives.
Was there intentional misconduct?
There was. And there's been an initial report. Judge Sullivan ordered a report on the day he dismissed the case against Senator Ted Stevens. On that same day, to the surprise of everybody, he appointed a distinguished Washington attorney named Hank Schulke to conduct an investigation. He worked 2.5 years, presented a 5-page report which outlines the misconduct, much of which was intentional. His assignment was a very narrow one, interestingly. His assignment was only to determine whether there had actually been a violation of criminal contempt. He said no to that because no specific order had been issued, which they violated. That's a different scope of investigation than is being undertaken by the Department of Justice. Their scope at the Office of Professional Responsibility is to determine whether Justice Department personnel, prosecutors, and then 1 or 2 FBI agents acted in a way inconsistent with the law, with Justice Department policies.
The Supreme Court, in its decision finding that prosecutors cannot be sued, said the professional ethics rules in most states are sufficient. Well, the majority just being naive there? Or what?
It's all. Sometimes you wonder, and there were wonderful people on the Supreme Court, but sometimes you wonder whether they had any experience out on the front line of law or litigation, to tell you the truth. And, well, that might be easy to say, but let's list the number of cases in which someone was disbarred for misconduct. I can think of only one right now, and that is the Duke lacrosse case in which the prosecutor, Nifong, was disbarred. And by the way, he actually served the enormous sentence of 1 day in jail for his misconduct of accusing Duke lacrosse players of rape and other misconduct, and put those teenage boys' faces on every magazine in the world. And his punishment was disbarment, but I can't think of any others.
How do you put a system in place that will work? What's the solution?
The solution is, in the final analysis, good people. When I go down to Georgetown Law School and lecture down there, I say to them, just because I've lived the life of a defense lawyer doesn't mean I've concluded that that is the best way to do justice. You can do justice even more quickly as a prosecutor. Be the prosecutor who makes sound judgments. Be the prosecutor who questions the police officer and has a healthy skepticism when the police officer reports the facts on a particular case. Have a healthy skepticism about whether that teenage driver actually had marijuana in the trunk, or did the cop place it there in the trunk in order to cause some college kid to be involved in the criminal process. So the prosecutors have the most important role on the front line of justice. Certainly defense lawyers do. And by the way, there are many defense lawyers that are not performing their jobs, that don't defend vigorously as our canons of professional ethics require. And of course, there are some judges not doing their job either.
In fairness to Eric Holder, he did ask the court to dismiss the charges against
Yes, he
Stevens.
did, and I must say, I praised him. I called him a hero. He had been in office less than a couple of months when new prosecutors in the Stevens case took over, and within 5 weeks found this evidence that had been hidden, all of which was exculpatory. And undoubtedly, I don't know the details within the department, but they immediately went to the Attorney General and higher-ups in the Department of Justice and convinced him that it should be dismissed. And that's what he did, promptly. He's to be given great credit for that. You have to go back to understand that the government, whether it be a federal prosecutor, Department of Justice, or district attorneys or attorney generals, have enormous power to affect the lives of the people they focus on and the families. And the system is so badly tipped in favor of the government nowadays that they have many different powers they can use. They can threaten to indict a spouse in a tax case because even though the spouse didn't know much about it, she signed the return. They can threaten to indict family members that are in the business with a particular target. They can threaten to bring 50 counts instead of allowing a plea to 1 or 2 counts. They can threaten to bring other kinds of counts, and they can choose between a panoply of potential charges.
Does this really happen?
Happens every day. Every day. I've been in cases in which the Justice Department has charged 350 counts against businessmen, a lawyer, a PhD professor, and others in order to make them plead guilty. In that case, by strange happenstance, these people believed they were fully innocent and went to trial, and the government was not able to prove them guilty, so they were all acquitted. But this happens all the time. Not only that, but in our system, sentences are so draconian that a person is actually betting his or her life when they decide to go to trial. Because if I were representing a particular defendant and was willing to plead guilty to 1 5-year count, I might hopefully get off with 3 or 4 years. But if you don't take that deal, then you're going to be charged with 25 counts. And if you testify, your testimony is automatically considered false, and that adds to the sentence. So it's a treacherous decision that's made whether one goes to trial.